All right. Hello, everybody. Thank you for kind of tuning in so that we can finish this lecture and you'll be good to go for your quiz or your exam. We're going to wrap up chapter 3 by talking about criminal defenses and the insanity defense. So, the law recognizes that a person is innocent until proven guilty, right? In the criminal law. So remember, we talked in class about criminal law, civil law, constitutional law, and um, administrative law. So in a criminal law, you have a defendant who is accused of a crime. And so remember that part of what has to be proven, or one of the elements of a crime, is your mens rea, or your thought and kind of trying to figure out why the victim or why the perpetrator did what they did. And so the law inherently gives us several types of criminal defenses that someone can choose to use. The first type, and I have these listed out here, you can read them, they're directly from your book, but you know, we typically see excuses, which provide what are known as mitigating factors to explain why someone engaged in criminal activity. You see justification used as a criminal defense, and this is um, used a lot in self-defense cases. So the person felt justified to commit the crime. So if someone breaks into your home, you shoot them, they die, uh, you that's called justifiable homicide. And so criminal defense, if they do prosecute, the defense can say, well, he was justified in shooting because he was acting in self-defense, right? Another type of criminal defense is known as an alibi. And an alibi is basically um, a person or situation that can um, vouch, I think is the best word to say, that can vouch for the defendant. So you see alibis used like in terms of trying to figure out where the defendant was at the time of the crime. So alibis are people or videos or something like that shows where the defendant was at the time of the crime. So if you're looking at it from a defense standpoint, your alibi would show that the defendant was not present at the scene and therefore could not have been the one that committed the crime. Then you have something that's called automatism. Automatism is it it deals solely on psychological. It's a psychological defense, and so you see this with post-traumatic stress disorder and severe mental health disabilities. You can see people claim that they were in a dreamlike state because of those disabilities. So that's a form of defense known as automism or automatism. Sorry. Another defense is a consent defense. Basically, this is victim blaming. And with a consent defense, the defense is saying that the victim gave permission to the defendant to act in an illegal manner against them. So sit and think, what could consent, like what what reasonable person could give consent for a crime to happen to them? Well, you see consent defenses a lot in sexual abuse cases, um, rape cases, property crimes. You can see defense or consent defenses, basically saying, well, so and so gave me that PlayStation. I didn't steal it. I had consent to have it. I will say that consent has been proven to not be a valid defense against assisted suicides. So that was big in the like 80s, and the courts have standing precedent now. Remember, we talked about precedent. There's standing precedent now that you can't use that defense in the situation of assisted suicides. So another defense that you see is something known as double jeopardy. So a person has rights under the Constitution. Remember, we talked about this, that constitutional foundation for law. And double jeopardy builds upon those rights, basically saying that a person cannot be tried and acquitted of a criminal act double time. So if a person is tried and acquitted for a criminal act in one trial, they can't be retried in another trial because they've already been acquitted of that crime. So if this is put in place as a protection, so if the DA, District Attorney's Office, goes to trial and the defendant is acquitted, they can't turn around and retry that case due to double jeopardy. And so it kind of protects defendants in the fact that they can't be tried twice for the same crime. You see defenses of duress and entrapment, and entrapment is used basically in terms of feeling like law enforcement convinced you to do something illegal through like tricking you and things like that. You do see entrapment come up a lot with confessions and things like that. If you watched Making a Murderer on Netflix, the Stephen Avery, Brandon Dassey case, there was a lot of discussion around Brandon Dassey's confession and whether it was done through entrapment, basically, or coercion. Coercion is a form of entrapment. And then you see something known as infancy. And infancy is a defense in criminal law for children who are unable to grasp the consequences of their actions. And you see a lot of this in kids under 7. The law typically will recognize 7 and under as not being able to fully comprehend their actions. So remember, infancy defense goes toward mens rea. So the thoughts, the intent is mens rea. All right. So we're going to continue with a couple of others. You see intoxication utilized, mistake of facts, self-defense. We've already kind of gone over that. So now let's talk about the insanity defense. And the insanity defense is a fun topic to look at, and because it's so nuanced as far as the details that have to go in. There's several different standards and rules when it comes to insanity defenses, and we're going to discuss those rules. Before I do that, though, I want to make sure that you understand insanity is a legal term. And the insanity defense is a legal term. Mental health does not diagnose someone as insane. There are comprehension assessments and things like that that have to take place whenever someone does an insanity defense. But know that if someone is found insane or successfully utilized an insanity defense, which only happens in about 1% of the cases. 1%. They are deemed insane to stand trial. All right, so I need you to understand that when we're talking about insanity and insanity defense, that is a legal term. That is not a psychological term. So there are some different standards when it comes to the insanity defense that we're going to go over. And the first one is known as the McNaughton rule, or the McNaughton standard. And this is basically a two-pronged test that has to be administered to tell whether the defendant knew right and wrong. So for the McNaughton rule, you're asking yourselves two questions. It's two prongs. You need to meet both prongs. So one, did the defendant understand what he or she was doing when they committed the crime? Mens rea. And did the defendant know that his actions were wrong? So the McNaughton standard is the right-wrong test. Did they know that what they were doing was wrong? And did they know and understand what they were doing was considered a crime? So the McNaughton rule was pretty much the standard for a while. And then the Supreme Court came up with a different kind of standard or rule to determine insanity defense. That is known as the Brawner rule. And the Brawner rule, it reduced knowing right from wrong to the capacity to appreciate the difference between the two. So where McNaughton was concerned with, did they know what they were doing was a crime, and did they know what they were doing was wrong? The Brawner rule kind of relaxed that a little bit. And that's looking at, does the defendant possess the understanding to know what his conduct was? And is the defendant able to control that conduct? So irresistible impulses could play into this. So then you have something known as the Durham test that came out of a Supreme Court case. And the Durham test basically says that a person cannot be held criminally responsible if the unlawful act was a product of a mental disease or defect. So if the reason that the Durham case is only worried about, do you find that this defendant has a mental illness? It doesn't care about where the McNaughton and Brawner rules were trying to differentiate between right and wrong and mens rea. The Durham test is just about, does this defendant have a mental illness? And then you have the irresistible impulse test. And that test is basically saying that if the mental illness is had by the defendant, are they able to control their behavior? And if not, then they can use the insanity defense. And one additional defense that falls under insanity that you wouldn't think of would be battered women's syndrome. And battered women's syndrome came about around the acknowledgement of domestic violence in our nation. And battered women's syndrome basically states that the actions that the woman who killed her husband was justified in doing so because she was a victim of domestic violence and in fear of her life constantly. Now, that is an oversimplification of the battered women syndrome. There's a ton of research out there around certain criteria around what does it mean living in fear, like can you shoot him while he's sitting on the couch not doing anything to you, or does he have to be in the actual midst of abusing you to utilize this defense. But for our introductory purposes, you just need to know that the battered women syndrome, or BWS, is a defense that presents an excuse to mitigate the actions of women who kill their abusers. This, I think, Monday, around how technology has influenced the criminal justice system and the law itself. Law enforcement may not be able to use certain technologies constitutionally anymore. We live in an age of technology, and so the law continues to try to keep pace with the evolution by incorporating provisions around technology use in law enforcement practices. There are two major cases that deal with technology effects in criminal justice. The first is the United States v. Jones, and in this case, a GPS monitor was attached to a car, and the defendant basically said, it's a violation of my constitutional rights, you're spying on me, it's overstepping boundaries. So the Supreme Court says that GPS monitors attached to a car is a search under the Fourth Amendment. And therefore, GPS monitors have to be held to the same standards as any other search. So a warrant probably has to be issued, and you have to go through the same procedures as you would any other type of search. So then you have Kylo v. United States. And this case was about a family who was growing marijuana out back, and law enforcement was using their helicopter and a thermal imaging camera and flying around the neighborhood checking out things, and busted this family for growing marijuana. And so this family sued all the way up, and it went to the Supreme Court, and the Supreme Court says that using thermal imaging to locate marijuana grown in a home was a violation of privacy. So our privacy rights have been upheld for the most part, within reason, in terms of law enforcement practices. We're still kind of wrapping our heads around body cameras, drones. Now we have like e-filing and things like that the courts do. So it's ever changing, and it will continue to evolve. Speaking of evolving standards, there are many types of laws that are outdated, and many types of laws that have to be enacted because something else happened. And so laws that are passed after a crime are known as ex post facto laws. And those you saw, like some of the hate crime legislation and the hate crime laws were passed after, like Matthew Shepard died, and kind of bringing those issues to the forefront of the consciousness. And so remember we talked about laws shouldn't be retroactive. They should be proactive, or not proactive, but they should be from the moment they're signed into law forward affecting, not necessarily retroactively affecting. But you also have to understand that laws are done and created because events have happened in the past. And so those ex post facto laws are there for a reason. You also have outdated laws that are extremely difficult to get rid of because, one, some people don't really know some of the laws. I gave my example of cow tipping, and I think someone told me after class that there was something about I want to say something about you can't wash a certain kind of animal in a bathtub and things like that. So it's difficult to kind of go through the criminal code a lot just to kind of weed out those outdated laws. And then also when we're talking about outdated laws, remember that societal norms shift. And outdated may encompass new societal norms that the law has not caught up to yet. So we see a lot of outdated laws as well. And of course, we've talked about white collar crimes having to evolve, laws kind of evolving in that arena just due to the use of technology. All right. So, more recent legal trends have moved toward including victims' rights and recognizing the victim. Most states have created statutes defining basic rights and protections for crime victims. And in 2013, the House of Representatives Committee on the Judiciary held a hearing that proposed something called the Victims' Rights Amendment. And the Victims' Rights Amendment is basically a list of rights that victims have. And so as we see the law changing and evolving, we're seeing victims being recognized. And next semester I'm teaching victimology, so we will talk a lot about victims' rights and kind of the evolution of those rights and things like that. So it's a really important piece of understanding our criminal justice system. All right, so that's going to conclude the remainder of the lecture. Like I said, I do have this PowerPoint up on Folio. It's in a PDF form, so you can just print it out. You have the study guide for the exam. Make sure you can answer the questions that are on that study guide, and you will be fine on the exam. So I hope everyone has a great rest of the week. Good luck Friday on your exam. If you need anything between now and then, please feel free to reach out. Thanks. Bye.